When your neighbor's tree falls down and damages your house, who pays? Stories behind real court case by Legal Lens. Imagine waking up one morning to find your neighbor's giant oak tree crashing through your roof. A freak storm knocked it down. But who's responsible? The neighbor who owned the tree, or you, the unlucky homeowner? This wasn't just a hypothetical dispute. In a quiet Canadian suburb, a real legal battle unfolded over a fallen tree, exposing surprising gaps in property law. The case would force courts to answer: when nature destroys your property, who pays? The story is a mix of bad luck, legal wrangling, and a precedent that still affects homeowners today. For years, two neighbors, let's call them Mr. Green and Miss Brown, lived peacefully side by side. The only tension? A massive, aging oak tree on Miss Brown's property, its branches stretching over Mr. Green's roof. Mr. Green had complained a few times about the tree's health, fearing it might collapse. But Miss Brown loved the tree and saw no urgent danger. Then, one stormy night, disaster struck. High winds tore the oak from its roots, smashing into Mr. Green's house, causing over $50,000 in damage. Mr. Green demanded Ms. Brown pay for repairs. She refused, arguing the storm, not negligence, caused the damage. With no resolution, the case went to court. The legal battle. The plaintiff's case, Mr. Green. Mr. Green's lawyers argued negligence. Ms. Brown knew the tree was risky, but did nothing, e.g., no inspections, pruning. Nuisance. The tree's overhanging branches were a long-standing issue. Precedent. Past cases suggested property owners must maintain trees to prevent foreseeable harm. The defense's case, Miss Brown. Her team countered. Act of God. The storm was unforeseeable. No proof the tree was dangerously unhealthy. No prior complaints. Mr. Green never formally documented concerns, just casual remarks. Cost burden. Requiring homeowners to inspect every tree would be unreasonable. Key evidence and delays. An arborist's report showed the tree had minor rot but wasn't an obvious hazard. The case dragged on for 2 years due to debates over what counts as foreseeable risk. Legal fees topped $30,000 for each side, the steep cost for a neighborhood dispute. The verdict. The court ruled in favor of Ms. Brown. The judge concluded: no negligence. Without proof the tree was an obvious danger, the storm was the true cause. Act of God defense. Extreme weather absolved liability unless neglect was clear. New precedent. Property owners aren't automatically liable for natural disasters, only if they knew or should have known about the risk. The ruling aligned with similar cases in common law but clarified limits on homeowner duties. Key takeaways. This case hinged on foreseeability, a core legal concept the court balanced. Fairness. Should Miss Brown pay for an unpredictable storm? Okay, responsibility. When does a tree become a ticking time bomb? Lessons for homeowners. 1. Document concerns in writing. Verbal complaints aren't enough. Regular inspections matter. Courts favor those who show diligence. Insurance is key. Many policies cover acts of God, sparing legal battles. Closing. In the end, the fallen tree didn't just damage a house, it tested the limits of blame. As climate change increases extreme weather, disputes like this will only grow. Was the ruling fair? Or should property owners bear more responsibility? One thing's certain, the next time you hear branches creaking in the wind, you might look at that old tree a little differently. Dive deeper into the courtroom drama. Legal Lens brings you the untold stories, gripping details, and shocking twists behind real court cases. Subscribe now to uncover the truth, analysis, and exclusive insights you won't find anywhere else. Don't miss a single verdict. Hit that subscribe button.